Hi. In this month's video blog, we're going to do a very brief summary of what a deposition is and what it means to be deposed and how you should act as a deponent. Depositions are discovery tools in lawsuits where we are allowed to put a witness or a party under oath and ask them questions just as if they were in a courtroom. And as I tell all of my clients before their depositions, the main purpose of the deposition is that the attorney needs to know what it is you're going to say and what it is that is inside your head so that they're not surprised if you say it later when you're in a courtroom or an arbitration. And that's about 90% of the purpose of the questions. There's more going on there, and certainly the attorney hopes that the deponent is going to say something that helps the attorney's client's case and hurts the deponent's case. But by and large, the main purpose of the deposition is to gain knowledge. When we have a client who's going to be deposed, we typically prepare them in various ways. It usually takes a couple hours. But if what I tell my clients coming in is if I disappear after the first minute of this preparation meeting, here's what you need to know. When you're in your deposition, you need to be truthful, reasonable, and cooperative. And it's not like you're sitting around Starbucks or talking with a friend about what happened truthful. It's scrupulously truthful. You need to know that if you assert something to be a fact, that it is something that you are sure of. And if you can't, then you need to explain the degree of your certainty. Depositions are credibility contests, and there's no jury or judge in the world who's going to reward somebody or even provide them with fair compensation if they believe that the person's trying to pull the wool over their eyes, if they don't believe that person is credible. So the deposition is an exercise in maintaining your credibility. And so you have to be scrupulously truthful. I would say in the same way as if a policeman showed up at your door and said, "I understand you witnessed a crime. I need to know what you saw." Well, you're going to be very careful about what you say in that circumstance. And this is very similar to that. Beyond that, the reasonable and cooperative parts come about because as a party, as a deponent, you wish to be perceived as credible. You wish to be perceived as somebody who's happy to answer their questions and you have nothing to hide. That is the surest way to allowing your attorney to then argue the case and do a good job for you. There is 3 minutes of what usually takes about an hour of discussion and review. So there's obviously much more to it, and you need to apply the specific facts of your case to the advice that's needed in order to do a good job at your deposition. But if nothing else, stick with being truthful, reasonable, and cooperative. And as long as your responses are filtered only through that mesh, then you're probably going to come out just fine.